Hi, everyone. Welcome to Crime in Court. This is the Canton cover up series, Commonwealth versus Karen Reed. And we also talk about Turtleboy on this channel, and that is exactly who we're going to be talking about, even though we're on the Karen Reed case, but Turtleboy has entered the Karen Reed case. So this is episode number 117, hashtag Hank tries to silence Turtleboy. So this is Karen Reed's case. This is special prosecutor Hank Brennan, who is making this motion for the records of Aiden Turtleboy Carney's records. This is totally to intimidate, harass, silence, whatever you want to call it. This is very over a very big overreach of the government, and I don't think that this should stand, but it's Beverly Cannoni's courtroom, so she's going to just be like, yeah, sure, Hank, whatever you want. So let's read this brief motion for Carney's records, and then we're going to also read there's an affidavit that Hank actually did provide, which is longer than the actual motion, which usually that's not the way it works, but let's get into it. Okay. Oh, please hit the like button and let's begin. This is the Commonwealth's motion for records from dockets, two separate dockets. I'm going to read those. And Special Assistant District Attorney Cosgrove, who is over the case as the prosecutor for um, Aiden Carney. So now comes the Commonwealth and respectfully requests this honorable court, pursuant to Massar Crim P17 and Commonwealth versus Lampron, issue a court order to Norfolk Superior Court in the matter of Commonwealth versus Carney, ordering Special Prosecutor Cosgrove to produce the criminal clerk's office of the Norfolk Superior Court. Number one, cell phone extraction reports and all underlying data from two phones searched pursuant to a search warrant ending in 71, as outlined on pages 15 through 16 of the Commonwealth versus Aiden Timothy Carney. In support of its motion, the Commonwealth states the following. On June 9th, 2022, the defendant was indicted by a Norfolk grand jury for second-degree homicide in violation of uh, Statute 265 for manslaughter, also while operating under the influence and leaving the scene of personal injury or death. On April 16th, 2024, a 10-week jury trial commenced. In addition to the three indictments, the jury was instructed to consider two lesser included offenses to manslaughter while operating under the influence, involuntary manslaughter in violation of the statute, and two motor vehicle homicide, OUI liquor, and negligence in violation. Okay, we get what all these are. Like, what does this have to do with Turtleboy? On July 1st, 2024, upon finding that the jury was deadlocked, the court discharged the jury and declared a mistrial. We have a footnote here that says, following the mistrial and discharge of the jury, the defendant claims the jury acquitted her on counts 1 and 3. And the defendant claims, no. The jurors claim that they acquitted her. It's not just that the defendant claims that, the jurors also claim that. On counts 1 and 3, and that prosecution is barred by double jeopardy. This issue is pending before the Supreme Judicial Court, and oral argument is scheduled to occur in November 2024. Huh? Proofreading. Hank, really, proofreading. It's not that hard. All right, the Commonwealth's opposition. Oh, wait, I went too far. The defendant's second trial is scheduled to begin April 1st. As I record this, we are 26 days away from trial. So it's getting close. That you can't do a whole heck of a lot in 28 days. It goes by fast when you're prepping for trial. So the records are evidentiary and relevant. How? How are Turtle Boy's records evidentiary and relevant? Commonwealth intends to file a motion in limine to admit phone records, documents, witness testimonies, and other information demonstrating intimidation of witnesses as consciousness of guilt evidence. How on earth can you bring in some kind of witness intimidation charge on somebody else in someone's case that they're both pending? Nobody's convicted of anything yet. How can you bring those charges in? I sure hope that they bring in a motion in limine to keep the charges out, but you know that Cannoni's going to want them in because in the last trial, both Adam Lally and the defendant stipulated that they did not want any talk of witness intimidation or Aiden Carney coming in. And Judge Cannoni was like, well, I don't agree with you. I'm going to let it come in. So ridiculous. This judge is an abomination. All right, the Commonwealth's opposition to the defendant's motion to suppress and to restrain any searching of computer and telecommunications devices for unreasonable delay, filed by Special Assistant District Attorney Cosgrove in Commonwealth versus Carney, docket number blah blah blah, sets forth the relevance contained in two cell phones belonging to Mr. Carney and were seized and searched pursuant to search warrant. Newsflash, Hank. The uh, Commonwealth already tried to get Carney and Karen on this like conspiracy, and when it went through and did all this garbage, trying to get more charges put on them, and it didn't work with the grand jury. So, how are we able to continue to w- just continue with this sham of these charges? It's ridiculous. I'm not in a good mood because I'm just so fed up and frustrated with the judicial system lately, and Canoni and Gull and Judge Weisberg in the Menendez case. And if you're paying any attention to that, the DA from the 1990s is coming forward and spewing a bunch of BS that's not even related to the Menendez. Like it's not even like she's spewing her theory, the narrative, but that doesn't mean that that's the truth. And this is the same thing here. The Commonwealth wants to spin a narrative, but that doesn't make it the truth. But they want to say that anything that the defense says is a narrative and it's just false. It's so ridiculous, and there's so many double standards, and I'm getting really fed up with it. But anyways, so let's move on. All right, so blah blah blah. Um, Let me start that sentence over again. On October, or did I even start that? No, I didn't. Okay, good. That's why I was confused. I was like, I don't know where I left off. All right, so on October 6th, 2023, the Norfolk Superior Court endorsed the Commonwealth's revised proposal for examination of digital material seized from defendant pursuant to search warrants issued on October 6, 2023, and incorporated memorandum of support in support thereof, which explains that on October 13th, 2024, data was extracted from Mr. Carney's cell phones, and on October 14th, 2024, Massachusetts State Police Lieutenant Tully analyzed the extraction reports from two phones. A team was established for 4 additional phones seized from Mr. Carney and have not yet been searched. So there's more phones that Carney is like, I don't even know where they're from, how old they are, whatever. Or I don't even know if they're mine. And they still haven't been searched, but they searched the most recent phones, which we know of, and they didn't find anything. So what the hell do they need this for? Like, I just don't understand, and this is so frustrating to me. Frustrated. All right, so search warrant ending in 71 makes clear that the information expected to be contained on the extraction reports would be material and relevant to the Reed case, and actions of this defendant. They're really trying to put him away, I think, again. This is garbage. They tried indicting him again. They put another charge on him, which is just incredibly insane. And it has to do with something like he was there at CF McCarthy's and he went up to the window at D&E Pizza. Like nobody was even there. And he went up to the window and was like caught on camera, basically like imagining like he was talking to Chris, although Chris was not there. Nobody was there. And so they're saying it was like witness intimidation. Again, like they're adding on another charge, which is just fucking ridiculous. Like I can't, I'm sorry to swear, but I can't take it anymore. Like I just cannot take the insanity of the Commonwealth anymore. It's so incredibly frustrating. Yeah. So, moving on. The Commonwealth, sorry, I had to get that out. The Commonwealth attests that the records are held within the care, custody, or control of the Commonwealth, but given the association between the Reed and Kearney defense teams, the involvement of special prosecutors, the Commonwealth seeks court authorization to obtain the material from one prosecution to use in another. The Commonwealth cannot properly prepare for trial without such production and inspection in advance of trial. I hope to God Turtleboy objects to this. I would object to this. I would be like, nah, you're not using any of my stuff in the Karen Reed case. And the failure to obtain such inspection may tend unreasonably to delay trial. The affidavit in support of this motion is attached for the reasons stated above. This motion should be allowed, according to Michael Morrissey and Hank Brennan, the most two corrupt people in Norfolk County right now, along with Canoni. Let's add Canoni in there. All right, so here is his affidavit. He actually did an affidavit. However, I can't. All right, so my name is Hank Brennan, and I am special counsel assigned to prosecute Karen Reed. I am moving to produce records in the above captioned matter pursuant to MR CP 17. On June 9th, 2022, the defendant was indicted by the Norfolk grand jury for second-degree charges, manslaughter, and leaving of a scene. The Commonwealth alleges that on January 29th, while intoxicated, the defendant struck John O'Keefe with the rear of her Lexus SUV and left him to die in blizzard conditions. Paramedics transported the victim to Good Samaritan Medical Center, where he was determined to be deceased. Canton police began to search for evidence in the immediate area around where the victim had been discovered. In the dark and through mounds of snow adjacent to the roadway, pieces of broken cocktail style glass and multiple areas of red that appear to be blood were recovered. Subsequently, hours and days later, pieces of red and clear plastic consistent with and later reconfigured to fit within the defendant's taillight were found on the lawn and roadway outside 34 Fairview Road. The victim's baseball hat and sneaker, which was flushed to the curb, like this, the wording in this. Okay, I can't. The baseball hat and sneaker, which were flushed to the curb under feet of snow, were also recovered. Or how about they weren't recovered the first time around, and yet they were recovered later and probably planted? Additionally, pieces of red and clear plastic were recovered from the debris within the victim's clothing, and the victim's DNA was located on the tail housing. The defendant's Lexus SUV was seized from the defendant's parents' home in Dighton on January 29th. The defendant has challenged the Commonwealth's evidence in this case to include allegations of police misconduct, claims that the Commonwealth tampered with evidence, and accusations that the Commonwealth has framed the defendant with homicide. Following an investigation conducted by a special prosecutor, Mr. Aidan Kearney was indicted by you mean like Ken Mello, who was caught, like literally caught, speaking with the fake victim and Brian Tully, that special prosecutor. So we're supposed to trust his indictments. Special prosecutor Aidan Kearney was indicted by the Norfolk grand jury for 16 charges related to intimidation and harassment of witnesses. It's 16. It always like it kept changing in the beginning, so I can't ever remember how many there are. So it is 16, now 17. Following the investigation conducted by a special prosecutor, Mr. Aidan Carney was indicted by a Norfolk grand jury for one charge of witness intimidation and one charge of wiretap violation. No, he wasn't. He was never charged of wiretapping, was he? Oh, wait, no, I think they tried to charge him on wiretapping for his conversation with like Lucky or oh no, 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 no. It was with Buchanan and it's a complete and total fabrication. I think it was wiretapping like because he was pretending like Sergeant Buchanan was in the bathroom with him. Like literally Sergeant Buchanan had been in the bathroom with him like 2 seconds prior and he left and then Turtleboy does what he does and he pulls out his phone and he's like, "Hey, I'm in here with Buchanan." And they said because he was recording with Sergeant Tully nearby that that's wiretapping or something. So I think that was the wiretapping charge. Like they're so disingenuous because all of the charges are such bogus, made up charges that everything that they say about him is a lie. And everything that they say about Karen is a lie. Like the whole narrative that he just spewed out in these few sentences. That's not exactly how it went. But whatever. All right, so Bev doesn't care that he lies. It's totally cool, but Jackson might misstate something or someone misunderstands what he's saying rather, and that is a big deal. It's such a double standard and so disgusting. As demonstrated by the search warrants generated as part of the special prosecutor's investigation, the Commonwealth alleges that beginning on or around April 17th, 2023, the defendant took deliberate action to start sharing defense theories, privileged materials. Oh, he took deliberate action, did he? Oh, the defendant. The defendant took deliberate action. And then and shared the evidence with Carney through an out-of-state intermediary. So what? It's not illegal to share public documents. Like he's making it like, oh, they were totally conspiring. No, they weren't. No. And if she wants to get her narrative out, she can. It's not a crime. So this is so disingenuous. Commonwealth alleges that the defendant instructed the intermediary to communicate with her through the signal messaging application, explaining that it provides secure and end-to-end encryption. Well, yes, of course, when you have corrupt pieces of crap like Brennan, it's a good thing that there are apps like Signal where you can communicate and the government can't intercept your messages. And instructed the intermediary to forward all information, which included witness information, home addresses, grand jury minutes, autopsy photographs, and generally every piece of evidence that the Commonwealth provided to the defense counsel on to Carney. The Commonwealth alleges the defendant would put disclaimers or directives on certain pieces of evidence, such as denoting "do not share," urgent, "do not publish anything from the report," and make it clear that he, Mr. Carney, didn't get it from us. But don't show the exhibits, just read them. Please tell him not to share the title. It has Yannetti's initials in it. Referring to Attorney Yannetti. Beginning in this, so what? None of this is illegal, but he's making it seem like, out of context, again, like trying to make it seem like these people are conspiring and doing something nefarious, and they're not. Beginning in the summer of 2023, the Commonwealth alleges the defendant and Mr. Carney would directly communicate on a regular basis. Call detail records from Mr. Carney's phone revealed that the defendant's phone number and Mr. Carney had 189 phone calls between June and December 21st, 2023, communicating for an excess of 40 hours. So what? Again, so what? This was reported to be in addition to frequent text and phone communications made through the encrypted Signal app. Yeah, you guys are mad that you don't have those communications, aren't you? You keep bringing it up. Pretty funny. Additionally, prior to publishing posts on his platform, Mr. Carney would seek permission from the defendant or her counsel. On July 14th, 2023, the defense filed an affidavit of Aidan Carney in support of defendant motion for recusal and disqualification of Judge Cannoni. There was an affidavit of Aidan in there? We did not see that. We didn't know. So, all the while back in 2023, they did file, the defense did file a motion to recuse and disqualify Judge Cannoni. They also did one for disqualifying Michael Morrissey. Both were denied by none other than Judge Cannoni. So, there's that. Call detail records from Mr. Carney's phone also revealed that phone numbers associated with Attorney Yannetti and Attorney Jackson communicated with Mr. Carney at least 29 times. Again, so what? A clear inference can be made that the parties directly encouraged Mr. Carney to continue personal attacks on witnesses? Get the F out of here. First of all, he never personally attacked or harassed, or he's never been charged, or he's never been convicted of harassment, intimidation. So, and there's no proof that Karen said for him to do this. So, again, I think they're trying to get her on witness conspiracy or something, possibly. Witness intimidation, conspiracy to commit witness intimidation. And their family members, including juvenile children. Colin is an adult. Colin's an adult. He's an adult now. So stop with the, oh, he's such a juvenile. With the sole purpose to embarrass, intimidate, harass, and deter these individuals from testifying. No. And when we just read in Bradel's motion to dismiss for Turtleboy's indictments that for words to For words to not be protected under the First Amendment, it needs to be a true threat, like a true threat, or fighting words. Like you really have to say, I'm actually going to take so and so's life, or something along those lines. It has to be a true threat. So nothing he has ever said has been a true threat. Nothing he has ever said was change your testimony or else. Nothing he has ever said has made it seem like he is trying to make them change their testimony or deter them from testifying. This is so ridiculous on its face. Deep breaths, deep breaths. We all have to take deep breaths and remember oxygen. We need to breathe. And these these people, these Commonwealth a-holes, just I cannot wait till their day comes. Mr. Carney publicly stated that the motion of his actions was to prevent this case from ever going to trial. That is such a bogus lie. These are all lies. He said he didn't want it to go to trial. And that's an opinion. You can say, I don't want it to go to trial, and that's not illegal. He said he didn't want it to go to trial, but personally, for his business, it would be better if it did, he said. But for Karen's sake and for her personal rights not being violated, he said he didn't want it to go to trial. There's nothing wrong with saying that, and that's not illegal, and that is totally not the context in which he said it. I hate Brennan so much. Like, I thought I hated Lolly. I miss the days of Lolly. I miss Lolly. I I can't stand. I can't determine who I can't stand more, Bev or Hank. Hank is really getting to be on that level, and it didn't take very long for him to get there. It has been represented to this court by defense counsel Tim Bradel and on behalf of Mr. Carney that there is an implicit, long-term, implicit mutual assistance and mutual defense agreement between counsel for Mr. Carney and counsels for this defendant. Motions and affidavits filed by Special Assistant District Attorney Cosgrove make clear that the information produced from both phones are likely to be evidentiary and relevant. So, District Attorney gave you motions and affidavits saying that this is going to be helpful for your case? Is that what I'm hearing? Is that what this means? I'm not really sure, but I don't like how it sounds. Commonwealth's motion is made in good faith. The Commonwealth intends to introduce evidence of the defendant's statements and actions to intimidate witnesses. They're trying to say Karen wants to intimidate witnesses from testifying against her as evidence of her consciousness of guilt, signed under the pains and penalty of perjury. Yikes. So again, they're trying to remind Aiden about all of his charges and his witness intimidation, wiretap violations, all this crap, and saying that they're trying to connect that Turtleboy and Karen Reed did something, conspired together. And this was already adjudicated in front of a grand jury, and they said there was no connection, no, whatever the answer is when they don't convict them or they don't charge them. It was like no undetermined or whatever it is. They weren't able to determine that they could they weren't able to determine that Aiden and Karen conspired to intimidate witnesses because they didn't, and it's ridiculous. And Judge Bev Canoni should deny this absolutely outright. But she's not going to. I really hope that Aiden objects, and I hope that Karen's team opposes this very strongly because this is just garbage. This is BS. Now all of a sudden, like, what does the witness intimidation have to do if you think that it's homicide charges? Like, if you are so convinced that she hit him with the car, why don't you focus more on proving that instead of taking away all of Karen Reed's defenses and all of her connections and people that are supportive of her? This is so it's so insane. I feel like my head's about to pop off. I wish it was Friday because I don't think I can take another day of this week just because of these insane people of the Commonwealth. But that's pretty much where I leave you. This was not a great filing, and that's all I have for you. Maybe we'll have some more filings soon. Oh, wait a minute. There's a decision. Hold on. All right, here we have a decision. Let me shrink myself so we can get to it. This just came in, hot off the presses. Decision and order on defendant's motion to exclude the testimony of the Commonwealth's witness, James W. Crosby. So remember, this is the gentleman who, he's former law enforcement. He did some dog molds of who he says is Chloe, who we're just supposed to believe is Chloe. And then he compared them to John's arm, his injuries on his arm, and concluded that it's not where his injuries came from, which this was highly contested. He doesn't have any kind of methodology whatsoever, and he shouldn't even be allowed to testify, let alone if she didn't want to, or if she didn't want to deny the motion outright, which she just did. She should have given them a Daubert Lanigan hearing, which she did not do. And he was not able to, provide any kind of methodology or any kind of background, scientific articles, things of the nature that you're supposed to provide when you are an expert witness. He does not have the credentials to be testifying on this, and he is not a medical doctor yet. Judge Canoni's like, sure, let him testify. I don't care. This whole courtroom is a shit show due to her ruling, so what does it matter at this point? After hearing and review of the pleadings, the court finds that the Commonwealth has satisfied the foundational requirements of a Daubert. Oh, what? No. The evidence will assist the jury. Dr. Crosby is an expert in dog bite wounds. There is an appropriate basis for his opinions in the record, and the proposed testimony, principles, and methods employed are reliable. The defendant's objection goes to the weight of the evidence, not its admissibility. She flat out said in her own courtroom that you need to be a medical doctor to opine about injuries. And now she has totally backtracked, totally contradicted herself. She says the defendant's motion to exclude the testimony of James W. Crosby is denied. And it just came in. She is corrupt. There's no other way to look at it. I've been saying this on my channel since probably the beginning. I've been saying she's biased from the beginning, but I changed my tune pretty quickly to just straight up corrupt. And I've been saying that for a long time, and I believe it. She is one of the most corrupt judges who just doesn't care and is publicly out there doing all this right in front of our eyes. And I want you guys to make sure that you share on social media and post on social media and, help spread the word about this case and this corrupt judge. And hopefully, we will start getting some justice in our justice system. I don't know how else to end this because it's just so frustrating and I'm tired of it and I'm annoyed with it. But it doesn't seem like Karen or Turtleboy are ever going to get a fair trial. Well, Turtleboy, I don't know what's going on, what may happen with him, but with Karen and the courtroom that she's in right now, she's never ever going to get a fair trial with Judge Bev at the helm. So they need to change it. They need to get rid of her, or the feds need to come and get her off the bench because she has no business being on the bench, in my opinion. Let me know what you guys think in the comments below about Judge Bev, about the denial of this motion to where she's allowing James Crosby, a dog behavioralist, to come and testify to dog bite wounds. Makes no sense. And then also tell me what you think about what Hank Brennan is doing to Aiden and how he is trying to now tie. I don't know if they're going to charge Karen with new witness intimidation charges or if they're just going to try to make it seem like, oh, this was because she's so guilty, which makes absolutely no sense. Wouldn't you want your story out if you were telling the truth? He is so dumb. Like so dumb. But he's not as dumb as Lolly, I'll give him that. He's at least effective in spinning the narrative. So, hopefully not too effective. And hopefully jury selection, by the way, is also scheduled for April 1st. So we are on target for an April 1st start date. At least jury selection will start, and then however many days it takes for jury selection, and then court will begin then. So stay tuned, and I will keep you guys up to date. And thank you so much for joining me. Please hit the like button on your way out, and I will see you guys next time. Take care. Bye now.